Justice Melcer was admitted to the bar in Israel in 1977, and I think has the distinction of being maybe the only member of the 15-member Israeli Supreme Court that actually practiced law and had his own commercial law firm for 30 years. That's, to me, as a trial lawyer and also someone interested in courts, is a very important qualification, because our courts in our country and your country probably need more people who have been seasoned in the trenches of being an advocate for clients.
It's already the first point I agree with you.
Huh? Good. And so he has been on the Supreme Court for over a decade now, and last year he was named the Deputy President, which is the second highest member of the Supreme Court. When he became a lawyer in 1977, I already had been practicing law for 10 years. But I had the great privilege of clerking on our Supreme Court for Hugo Black. And I have seen and witnessed the changes in our court over the last 50 some odd years, which has been amazing changes. Justice Melcer, I'd like to begin by just commenting on the fact that everyone in this country has become an expert on courts in the last couple of months. They know what petitions are, they know what writs are, they know what law clerks are, they know, and they certainly are familiar with how the Supreme Court gets appointed in this country. We have the controversial and
Or disappointed.
Right. They are disappointed, or not appointed. The Time magazine this week had an article on commenting on the fact that our court has become so central to our everyday life in this country, to what we can do, to who we can marry, to procedures we can have, to what we can say, that it was bound to end up being a very politicized and divisive institution. And so my question to you, starting question, is there anything comparable, anything like that in Israel? I mean, is your court, I mean, all of us know that the two Supreme Courts that stand firmest for individual liberty and democratic principles are our Supreme Court and your Supreme Court. But has your Supreme Court ever gone the way of this divisiveness? That's my first question. Can you imagine something like this happened in this country in the last 3 or 4 months happening in Israel?
Okay. I'll answer your question in a moment, but before that, you know, it's a Jewish tradition that whenever you start talking, first of all, you have to praise the house and the hostess. So I take the liberty, it's called, you have to speak B'Shevach HaAchsanya. So I take the liberty to thank you for your hostess and to thank John, Victor, and the whole Victor family. And because it's my last talk in the very short tour that Margalit and I made, I want to thank also to the Shabtai organization and all Shabtai members which brought me here and brought me to the law faculty in Yale, and I had several talks there, and really we enjoyed it a lot, the hospitality of the Shmuley family, and of Toby and Rabbi Shmuley. And I must tell you that what Margalit and I were amazed is the high level, because here there are many alumni from Yale, the really high level of the students of Yale, which is uncomparable to other universities I've seen, and I've also taught constitutional and administrative law in the Tel Aviv University. Really, the students are in a very, very high level, not to speak about the professors. So, and before I answer the question, the last thank you is to Mr. Steve Susman. Steve, okay, and his wife. I must tell you that when we were in New Haven, we went from one event to the other, but we had the time to see the gallery of Steve's that he donated to the Museum of New Haven, and really it's magnificent. So now I finished my thanks, and I'm coming to your question.
Let me ask the question again, better. than I
Okay,
did.
better. Okay.
This is what Time magazine said last week. Quote, in a nation divided left and right, we are coming to view the court less as an interpreter of the law than an activist imposer of moral and political outcomes. Can the same thing be said of the Israeli Supreme Court?
Okay, so the answer is in the affirmative. I must tell you that we are a very strong court. We are criticized by several circles that we are too much activists, and in this area might be that we are even more activist than the U.S. Supreme Court. But I think it's good that we are doing it, because sometimes we save Israel from, or the other branches of government from their deeds. And so we are criticized several times by the right-wing parties in Israel, sometimes by the left-wing parties, which shows you that we are okay. Because when we are criticized by both sides, it means that law and justice is our purpose, and we try to achieve it, and we achieve it. But you know, law is such a thing that in every case, per definition, someone loses. And the one which loses, always, or not always, it's very rare that he accepts the outcome. So we are criticized by both parties, and that's okay. But we are very strong, and I hope we will be strong in the next future, because from time to time there are initiatives to limit our power. And for the time being, we have succeeded to block those initiatives. I don't know for how long, but for the time being, that is the situation. And in a moment, probably I'll give you some examples.
How many judges are on your court?
Okay, we have 15 justices.
How are they appointed?
Okay, there is we have a very special system of appointing judges in all courts, in the county courts, district court, and the Supreme Court. There is a committee composed of 9 people, 9 members. The chairman of the committee is the Minister of Justice, and there is another minister elected by the government to be a member of that committee. The other members are 3 justices of the Supreme Court.
Including you.
Including me. And then there are 2 members elected by the Knesset, by the Parliament of Israel. Usually it is 1 from the coalition and 1 from the opposition, and 2 representatives from the bar. Okay, so altogether it's 9. Now, in order to be elected a judge in the county court or district court, you have to have a regular plurality of 5 votes out of 9. In order to be elected Supreme Court Justice, you have to have 7 votes out of 9. And by the way, the many countries in the world that have different systems, and the United States as well, they really come and to see how it works in our country, and they think that it's one of the best systems for electing judges.
Yeah, because if you have a super majority required to appoint a judge, it's much more likely that the judge is going to be central or centrist, right,
exactly.
in our country,
and
where 50 senators can make the decision.
Exactly, and it's not only that. If you analyze the composition of that committee, you see that 5 of 9 members are professionals and 4 are politicians. So the profession has the majority in the committee, and due to the fact that you need to appoint a Supreme Court justice, you have to have 7 votes. You have to have 2 more votes beside the 5 professionals. Of course, sometimes the representatives of the bar are also political people, so you have some kind of a balance. Another thing different from what you have in the United States, we don't have public hearings of the candidates. We have hearings, but they are not public. And the hearings are in camera, and people are being asked all different of questions. Of course, before they are declared candidates, there is a security checkout and other clearances that they deserve in order to be candidates. And then there is a hearing, but the hearing is before the committee and not before the public. It's not public hearing. That avoids scenes like we've seen here, okay? And I don't want to comment any further on what happened here.
I'm not going to ask you to comment on what happened here. There could not be this kind of hearing on television, in other words. A justice on your court, in our country, as you know, some people think they're appointed for life. In fact, our Constitution says they serve during good behavior, not for life. So they misbehave, whatever that means, they are no longer protected by the Constitution. But what's the tenure of your justices?
Okay. Here again, we have, I think it's a good system. Whenever you have your birthday of 70, by law you have to resign, or you are resigned by law. So at the age of 70, you have to you stop being Supreme Court justice, and I think it's good. I have two and a half more years to go, but everyone knows when he will end his term of office.
When the court sits and hears a case, of course, our court sits en banc, 9 justices sit there. Do your usual cases come before an en banc court or 3-judge panel? Okay,
we have here we usually sit in panels of 3. In constitutional matters and in very important cases, we will sit in larger panels of 5, 7, 9, 11, and 13 justices. 13 justices were just twice, but the 2 other justices in that case, and in a moment I'll explain you why, are not sitting because they have to deal with the urgent matters that come before the court. So usually we sit in panels of 3. In very urgent cases, when you need to issue a temporary injunction, there is one. It comes before 1 justice, but then it's being transferred to a larger panel. And here you have, in order to make a fair comparison, the U.S. Supreme Court hears about 100 cases per year after you get a leave to appear before the Supreme Court. Guess how many cases we are hearing per year?
Actually, you mean actually hearing oral argument on?
That's right.
Several hundred?
Okay. We hear oral arguments in 4,000 cases per year.
Wow.
Now, beside that,
How much do lawyers get? 3
Okay.
minutes each?
no. But to be fair in the comparison, due to the fact that you usually will sit in panels of 3, you have to understand that every judge is almost sitting on about 1,500 cases per year. And as a matter of fact, again, we really refer many times to the U.S. Let's say legal history, and to your decisions. We didn't have yet a justice like Chief Justice Taft, which made a reform in your system and said that in order to appear before the Supreme Court, you have to get a leave, because before Chief Justice Taft came into office, and you have to remember he came into office after he was the President of the United States. So he had still, people thought he has still the power of a president. So once he came into the court, he said it's really not reasonable that we hear by way of right all the cases. And he said, I give an ultimatum. Again, he thought he is still the president of the country, and you have to change the system so that you can come before the court just when you get a leave. In Israel, every aggrieved person can come before the Supreme Court by way of right, as a way of right, and you don't need to take a leave or to get a leave. So the workload is terrible, but that is a difference, and I think here that the U.S. system is better. Now, we wanted to change it several times, but in Israel, in order to change it, you have to change the law, and in order to change the law, you have to get a consensus between the court, the Minister of Justice, the government, the parliament, and the bar. And you can imagine that such a consensus cannot be reached. And as a matter of fact, first of all, we are Jews, mostly there. So it's very difficult to get such a consensus. And beside that, let me put it delicately, many organizations do not want us to be as the U.S. Supreme Court, because the U.S. Supreme Court is dealing just with the heavy, important cases. And there are some elements that would like us to deal with the small cases as well, or basically with the small cases.
Of the 1,500 cases,
Yeah.
say you would hear maybe 1,500 cases?
That's right.
Of those cases, how many will be decided by a written decision?
All of them.
All of them?
All of them.
So in our country, where you have less than 100 cases, maybe 80 cases orally argued, thank you, where you have 80 cases orally argued a year, each of the 9 justices has 4 law clerks. And they have become very kind of divisive, I would say. There are a huge number of dissenting and concurring opinions written. And does the Israeli Supreme Court, do you write many dissents or concurring opinions?
Okay. So first of all, that is something similar to what you have in the United States. Every Supreme Court justice has 4
law clerks.
By the way, it wasn't so when I came to the court, due to the fact that I came from the private sector and I saw the workload. I told them that it's nonsense not to have more clerks, and it was a small reform that I had initiated. And again, it's another sign why it's good to have someone coming from law firms into the public sphere, because they understand that, to get more law clerks is nothing incomparable to all the expenses that the court has. So it has things go in Israel, it's not like you ran a very big law firm. In my eyes, I told them, in my law firm, I would make the change within a day. It took 2 years to convince them that it should be made, and then 2 years later to implement it. So you understand that's
Right.
the difference
So-
between the private sector and the public sector, but still it was done. So now every justice who is coming to the court, first of all, he comes to my chambers and say, thank you.
But do they? But Well, let me
now,
ask-
Now about the majority
Dissenting.
and dissents. We have, I would say that about 65% of the judgments are by consensus, 35% are by dissent. And if just 5%, if we are sitting in panels of 3, there are 3 opinions just in 5%. Usually it's 2 against 1.
2-1.
And in the constitutional matters, sometimes I know already what will be, or I think what will be your next question. So I'm telling you,
No.
usually in large panels, there are still 2 main opinions, and there is the majority and the minority. It's very rare that there are 3 opinions in large panels.
So, in our country, this has changed too. It's very easy to identify the justices who are on the right and the justices who are on the left. That division is 5-4
Yeah.
today.
It was 5-4.
It was
It will not be any more 5-4.
okay. Yeah, that's gonna be.
It's,
So, can you identify? Can people say the same thing about the Israeli Supreme Court or the 15? How many would you consider Ruth Bader Ginsburg's, and how many would you consider Samuel Alito's or Scalia's?
Okay. Okay.
I bet you can name them.
No. Okay. I'll tell you. First of all, due to the different system, it's not a political appointment.
Right.
So I described already how the selection committee is composed of and how it works. So it's not political. The nominations are not political. However, to be quite frank, the politicians in the committee try, whenever they are in the coalition, to try to bring, and I must tell you, and the same goes in the United States, very professional justices, but who tend to be on more or less on their side. Now, it happened in Israel and in the United States as well, as you may know, that justices who at the nomination were, let's say, were
Leaning left,
leaning to the left,
switch to the right.
switch to the right, and vice
Vice
versa. And the reason is that we have to decide according to law. Now, in the United States, in the last, I don't want to comment too much, but I'm quite familiar with what is going on in the United States Supreme Court. That tendency that sometimes a judge that was nominated by the Republicans tended later on to be a liberal, and vice versa. In the United States, it is less and less now. In Israel, still we are, let's say, if you compare in the era before the era you had in the United States. So, for instance, Chief Justice Roberts, he voted for the Obamacare plan. We have such cases in Israel as well. As a matter of fact, if you'll about a month ago, I was not on the panel. There were several women from Gaza who had cancer, and their husbands were active in the Hamas terror organization, and they wanted to get medical treatment in Israel, in Israeli hospitals, but and you have to understand there is a lot of tension now in Gaza against Israel, and they wanted, and their husbands were military activists of the Hamas, which is a terror group, and they wanted to get in. Now the military commander didn't allow them in, and a panel of 3 judges decided that they should be let in. Now, why I'm mentioning it? For 2 reasons. One, in this panel, there were 2 justices who were nominated as right-wing justices, and they decided to let them in. The second reason I'm mentioning it, because the Supreme Court of Israel is the only court in the world that allows people from Gaza and from the West Bank to file petitions directly to the Supreme Court. No other court in the world allows it. And really, jurists from all over the world are coming to see this miracle because, for instance, in the United States, people that are captured, for instance, in Guantanamo, cannot appeal to the legal system of the United States, and we allow it. And we are really very unique in this feature. And now the Palestinians say that we are so smart that we allow it, because once we allow it, the Palestinians cannot go to international tribunals because they get their remedy in Israel. But I must tell you that the Palestinians who do not recognize Israeli authorities and Israeli organs, the only organ that they are willing to accept is the Supreme Court of Israel. And they are filing petition to the Supreme Court because they feel, and that is the only organ that they accept, because they feel that in our Supreme Court they get justice. Now, whenever we make a decision in their favor, we get a lot of criticism. So was the case in this judgment that I just described. And if we deny their petitions, then we get criticism from the left side. So still, it's the only court in the world that allows it. And getting back to your question, in this panel that decided that were 2 justices out of 3 that were considered to be conservative, to be from the right wing, but they said they thought that international law and humanitarian law allows it, or they should get help in Israeli hospitals, because they could not get help in any other hospital. So that shows you something.
So let me, more basic, because I don't really understand how it works in Israel, but our justices are in charge primarily of interpreting our Constitution, which is a document that's over several hundred years old.
Yeah.
And there's this big argument in this country on the court about whether you should be an originalist and go back to what the founding fathers meant when they wrote the document. You don't have to go back that far in Israel, but I assume. Well, you don't have do you have a constitution? That's my question.
Okay, I'll explain. As a matter of fact, we don't have a full constitution. But once the State of Israel was established, the first elections for the Knesset were aimed to form a constitution when the country was established. After the people were elected into the Knesset, then Ben-Gurion and the religious parties thought it's not a good idea to have a constitution at that moment, basically because of two reasons. First of all, no government likes to be constrained by a constitution. No one in any other country in the world. And so was Ben Gurion. Besides that, the question of the relationship between the religion and the state came up. So what they decided as a compromise, and it's called the first legal revolution of Israel. What was decided that there will be a constitution, but not in this the term of office of that parliament, but constitution will be drafted within a period of time. They didn't define the period of time, but chapters by chapters, and every chapter will be called a basic law, and the basic laws will have the force of chapters in the constitution to come. So now we have about 15 basic laws. I say about because there's a dispute of one or two laws, whether they are basic or not. But we have those basic laws, and the next step was whether we can declare a regular law unconstitutional because it contradicts the basic laws. And 20 years ago, more than 20 years ago, our court, the Supreme Court, decided that very much like the US Supreme Court in Marbury versus Madison, decided that we have the power to declare a law unconstitutional, and if it contradicts the basic laws. Now, it's very interesting because we made the same move like the US law, and if you know the US Constitution, in the US Constitution, there is no provision saying that the Supreme Court of the United States is allowed to declare a law unconstitutional. So we made the same move. We cited Marbury versus Madison, and then that was decided on the principle. Then the question was, who will be the first one to have a law declared unconstitutional, and many jurists wanted to be the first ones. And as being a litigator, in a moment, I had the privilege to be the first one to make a petition to the court and to declare several provisions of the law unconstitutional. And just to tell you that when the clients came in and asked me to represent them in court, they wanted a reduction in the fees. And I told them, you'll get the reduction. I didn't tell them that even if they would have asked me to do it pro bono, I'll do it, because I knew that's a good case to be the first case to declare law unconstitutional. So later on, we made a party, and then I told them that I was willing to do it for free, and
sure, they were delighted to hear that.
And I gave the money for public purpose.
So let me ask you about. Let's go through the individual rights. An American and Israeli. An American under the First Amendment enjoys the right to freedom of speech. Is there a similar right in Israel guaranteed by written basic law?
It's a good question. We have several rights written in. We have a basic law called the Basic Law of Liberty and Dignity. Now, we don't have something similar to the First Amendment as far as free speech is concerned. So what we did in order to safeguard free speech, we said that free speech is a total right from the right of dignity. And by the way, here is the Consul General of Israel, his nephew, I think it's your nephew.
My
your cousin. We based it, the principle no, first of all, the principle to declare laws unconstitutional, we did by citing Mary versus Madison. And here it's connected. On the technique that we made the right of speech a daughter right from the right of dignity, we did it in several ways. One way, we based ourselves on the doctorate thesis that
In Yale.
sorry?
The doctorate thesis in Yale. In Yale
Yeah,
University.
it's just that she made in Yale. And now she's not practicing law, but she's probably the most well-known journalist in Israel. But one of the...
I protest the word probably.
Okay, so that was the way. So the technique was that whatever rights are not written directly in the, let's say, our charter, we say they are
Part of dignity.
They are either part of dignity
Or
part
liberty.
of liberty. And now we have already daughter rights, and we have now formed even granddaughter and grandchild children of that right. So that is the technique. By the way, other Supreme Courts made the same technique. If something is lacking, if you have two basic rights like liberty and dignity, you can put into it other rights. So you are much stronger in the First Amendment, but we can manage with it as well.
But freedom of press too is covered under free speech.
Okay.
But of course, freedom of religion. How about freedom of religion? We have.
Okay.
I better stay away from religion.
Okay.
Let me go.
No, but let me say something about freedom of the press. We have now a case. I am presiding. It's 9 judges, but we didn't issue yet a judgment, so I don't want to comment. By the time, till now, we just declared the freedom of speech as a total right of the right of dignity. The parties argued before us, and we are going to issue a judgment. But of course, I cannot comment.
Don't.
Okay.
Let me ask you. So, I assume the Second Amendment's the right to bear arms, but Israelis carry guns around most of the time anyway, don't they? So, that's not totally equivalent. How about our Fourth Amendment? Literally guarantees the right to be free from unreasonable searches and seizures. And our court has implied from that a right of privacy, and implied from that a right of a woman to choose whether to, end a pregnancy or not, or to take contraceptives, all derived from the Fourth Amendment. So in Israel, for example, do women have the right to choose or not?
Okay. So first of all,
Protected by law.
First of all, we have in this basic law of liberty and dignity, we have a specific right of privacy in the basic law. So as far as privacy is concerned, we have it in the basic law. Now, in Israel, we are very liberal, and women have the right to choose their way in those matters, and in all gender matters, we are probably the most liberal court in the world. And again, I don't want to comment anymore because there are still 2 cases to be decided. But with women right to choose what to do with pregnancy, we are very liberal in let's say in comparison to other jurisdictions, and in other matters of gender we are also liberal. I don't know whether we are the most liberal country, but we are very liberal.
Okay. How about, do you have anything here in Israel? Well, how about, so I read in the New York Times last week that there is a 22-year-old woman who went to Israel to study, who has been ordered deported because she was active in a organization in her university in Florida that is supporting the boycott. Boycott.
BDS.
BDS?
Yes.
Okay. And there's apparently some law that says that in our country, they don't have any right.
Exactly.
They are deported without a hearing, without their children, and incarcerated mostly without a lawyer. I'm from Texas, so I know what's going on at the border. But this woman apparently is going to get some kind of hearing in your country. She has, actually the deportation has already been stayed according to the article. So how could that case come before your court?
Okay. So first of all, I'll update you because on my way here, there's okay. I'll update you because on my way here, I got a piece of news from my court about that. So first of all, and you're right, it's different here and in our country because here the immigration officer can tell such a woman that he is deporting her. He doesn't have to give any reasons, and she doesn't have any legal remedy whatsoever. In Israel, she can make a petition, first of all, to a quasi-judicial person from the Ministry of Interior, then to go to the district court sitting as an administrative court, and then to appeal. So she has 3 chances, and then to appeal to the Supreme Court. Now, she was denied by the quasi-judicial officer from the Ministry of Interior. She was denied by the District Court of Tel Aviv, and today in the morning in Tel Aviv, in Israel, she had made a petition to the Supreme Court, and her deportation was stayed, and a panel of 3 will hear her case on Wednesday. So
pretty damn quick.
I don't want to say any further because due to the fact that I'm going back on Wednesday, I'm not on the panel because most likely would have been that I would be on the panel, but they might be after, if the answer will be in whatever answer there will be, someone may ask for a larger panel. We have such a procedure on bank. So I don't want to refer any further, but it shows you how things are being dealt in Israel in comparison to what is done in such cases in the United States.
How about jury trials? That's my favorite subject, as you know. So are there jury trials in criminal cases in Israel?
No, we don't have any jury trials, neither in criminal cases nor, of course, in civil cases. And I must tell you that once such a suggestion was made to bring jury trials to Israel, but it wasn't accepted. And you have to understand it's very difficult because here people who are sitting as juries, they are elected, and they have to sit as reserve duty in Israel. We have enough reserve duty. So, beside having people going to the army as reserve duty, to add, even from this point of view, to add more duties on the citizens is difficult. And there is also criticism about the knowledge of the people of the law. By the way, I'm not so sure that in criminal cases, let's say regular, reasonable people will not have the same logic that a judge has, because as far as facts are concerned, not legal matters. So, but still, we don't have any. The answer is we don't have any jurors.
Justice, a Jewish jury would be a nightmare.
Okay.
So here's the final question. I want to throw it open to the audience. When I was clerking for the Supreme Court, its public approval rating was, they didn't have a Gallup poll, but my assumption was about 80% of Americans approved and had confidence in the job the Supreme Court was doing. That dropped about 6 years ago to as low as 40% of the Americans. I would have thought that it was even lower today, but in a Gallup poll conducted this summer, the approval rating is up to 53%, so it's recovered from the all-time low. No poll has been conducted since the Kavanaugh hearings, but my suspicion is it's down in the toilet again, that approval rating. Is there any comparable opinion poll done in Israel, and what degree of confidence does the Israeli citizens have of your court?
Okay, once it was, first of all, we have something similar. Once it was 80%, we went down into about 65%, and I hope from now on, we'll go up. But it went down to 65%. I don't want to analyze now all the reasons for that. And I hope, and we are, as far as we are concerned, we are trying to do the best at the utmost so that it will come to 80% as well. We have a problem that several politicians are really attacking the court very firmly and not politely. And one of the members of the Knesset said that that a D9 should be sent to the court in order to ruin the court.
A bulldozer.
A bulldozer.
A bulldozer.
Yes, and then to finish the Supreme Court. He apologized later on, but now he came back to his to those words. That helps, to disrespect the court. For the time being, there are not too many like him, but of course it causes harm to the court, and you have to understand there should be a dialogue between the all branches of the government, of the state, the parliament, the court, and the parliament, the government, and the court. The problem is that this dialogue should be handled politely, and once it's just politely from our side, it's difficult to handle. And in spite of the fact that he said what he said, we didn't react, and we do it our way, and we speak by our judgments. But might be that if it will go on like this, we'll have to react as well. For the time being, we are gentlemen. And
we have something to learn from you.
And we are ladies as well, because there are about four, before there were 5 women justices in the court, now there are 4. So we behave like gentlemen and ladies, and we do not react, but it might be that we'll have to react.
Now, any questions for Justice Melcer? Anyone's got some questions? Yes, sir.
One thing that I'm taking
Can you tell us who you are?
Oh, sure. My name is Ian Shapolsky, and I was invited here as a guest of somebody that attended Yale. And I've been involved in Jewish book publishing in the U.S. for about 20 years. So my question is, it seems that if somebody brings a case, there could be a permutation of 3 different groups of 3 of you justices deciding it. So isn't it very possible that that case, depending on which group it goes to, could have a different outcome?
Yes.
And is there any way that the case could be manipulated to go before a certain group that they would prefer?
I got your question. First of all, it might happen, but not the manipulation, because we have a very firm system how the justices are being delegated to each case. So there is no manipulation, but due to the fact that there are 5 panels, it might happen that there'll be 2 contradicting judgments. In that case, that is the one cause whereby if such a thing happens, that's one cause that you can ask for a larger panel, and that we took from the continental system. And in such a case, then almost for sure, then either the Chief Justice or me, we decide to enlarge the panel and to have the justices of both panels in the panel plus another 3 justices, so altogether 9, and they hear de novo the case. Okay, so that is the system. And that is
Similar to our courts of appeal, where there are panels of 3 judges.
Exactly.
But if they disagree, there's an in-bank
Exactly.
procedure.
Exactly.
Yes, ma'am.
So I'm John Victor's mother.
And Stephen Victor too.
Well, because he's the that's Stephen Victor's mother too.
Because John's brother is here with us.
And Gail's sister-in-law. So my question is, I'm a lawyer, so I'm thinking about certain cases in this country that get a higher investigation or strict scrutiny. I guess Steve would maybe frame the question.
Strict scrutiny.
So what kind of cases would take a very serious review from the Supreme Court?
Okay,
So
first of
for-
all, constitutional matters get usually from the beginning large panels. For instance, in order to declare a law unconstitutional, you have to have a large panel of at least 7 justices. Okay, so whenever comes before the court a constitutional question or a question whereby a law can be declared unconstitutional, we see it at least with 7 justices, and sometimes even more justices, 9, 11, and so I told you twice, 13. Now, other cases, there are, sometimes there are very light cases, then we hear them in panels of 3, and they are very, we get written arguments, and the oral argument is very short. And in major cases, we get in every case we get written arguments, but in heavy cases we hear arguments for about an hour. And constitution matters may happen that we hear arguments for a day and sometimes even 2 days.
I think what I'm thinking of is like a law that's passed that abridges somebody's freedom of religion. I mean, it's a religion or race or gender.
Those cases will be either, first of all, they be heard usually by larger panels, and at least we'll hear the case beside the written arguments for about an hour, sometimes more than that. Yeah.
We mentioned.
Brendan,
My name's Brendan Helwig. I graduated Yale just
Graduate of Yale in what?
in May.
In-
I studied ethics politics. in
Sorry?
Massachusetts. I studied ethics politics. in
Okay. Ethics, politics, and
Economics.
economics. Okay.
So most justices on the Supreme Court today served on a circuit court and have a pretty typical path up to be joining the Supreme Court. But in the past, including Justice Black, who you said you clerked for, and Taft, who we mentioned earlier, there are other paths into the Supreme Court. You mentioned your service in or your work in the private sector as well. What's the typical path people take up into these early Supreme Court?
Okay. So we have in those 15 justices, we have a very interesting combination. There are the majority are justices that came, as you said, from the circuits or from the district court. So there are 7 or 8 justices coming from the system coming from the system during the years. Now, beside that, usually there are 2 or 3 coming from the academia, professors, law professors. Usually two are coming from the Attorney General office, and they are let's say, they take the criminal attitude, and 2 are coming from the private sector. Now, one of the justices that came after me from the private sector, after 10 years, he has resigned because of the terrible workload, and he said 10 years it's enough, and I hope if I'll be healthy enough to resign at my 70 years birthday, but I think that because now I'm just one justice coming from the private sector, and you know there is a Hebrew proverb saying, "Tovim hashnayim min ha'echad." It's better to have 2 rather than 1. I hope that later on another justice will come from the private sector, and at least 1. And when I resign, I hope someone will replace me also from the private sector. Now, this cocktail gives a good combination, because everyone has his knowledge and his experience and his attitude that he has formed during the years. So I think that it's good to have this combination, and it's good that the majority of the judges are coming from the inferior courts, but still you need to have the academia, the Attorney General. As far as I'm concerned, I think there should not be more than 2, and from the private sector.
Our Supreme Court, by the way, is not supposed to be a fact finder. Facts are found by the trial judge. I gather that your Supreme Court does more fact finding than we do. For example, one of the controversial decisions, I Googled you and I found out it's controversial decisions. One was when the court, he was on a panel of 3 judges that authorized the Israeli Defense Forces to use live ammunition at the barrier between Israel and Gaza, in which a number of people were killed recently. So, is that right? Did I get it right? You were on that opinion, and it was some notoriety there.
Okay. So
tell us about that.
Okay. So first of all, you're right saying that we are more flexible with the facts rather in comparison to the U.S. Supreme Court. Secondly, you have to understand, again, there is something very special and unique in our Supreme Court, that in such cases, you can file a petition. It's not like in the United States that it goes from downwards to down up. You go straight to the Supreme Court in such cases. In a moment, if we'll have time, I'll explain why it is like that, and it has historical reasons as well. But usually we do not comment on our judgments, and I wrote the main judgment there in this case. And you have to understand the situation, and we got affidavits, and so we fixed the facts there. And you have to understand, in that case, it just happened to be that thousands of Palestinians made demonstrations on the fence between Gaza and Israel, and it looked as if it's civil demonstrations, but they didn't come with flowers. Most of the people didn't come with ammunition, with guns, but there were active military Hamas people in the crowd, and Hamas organized all those demonstrations. Now you have to understand, when about 15,000 people are demonstrating near the fence, and I'm trying to go in, by they called it civil demonstration
Disobedience.
and disobedience. And once they start running into the fence, the question is what you have to do according to law. There was no such, it's now, my judgment is a worldwide precedent because such a case never ever came before any Supreme Court before. I based my case, there was, it's very interesting, there was a Red Cross conference and a professor has raised this question theoretically. What happens? And he said in this Red Cross conference that in such a case, if it will occur, I don't know whether they got the idea of the professor, he made a theoretical question, but then the answer was that in such a case, you are allowed to shoot the people in the theoretical case. And I based my judgment on the theoretical case. Now, they have claimed that it's just civil disobedience, but we found out and that the people who were killed, sometimes you miss, but 80% of the killed people were, just happened to be, were officers of the Hamas. So, and that we knew when we heard the case. So, first of all, I based my case on Red Cross conference, which and was adopted by the Red Cross. Secondly, the fact was that innocent people were not found killed. Just, I say 20% were, let's say, it's either we didn't find who they were or they were, but 80% of the killed people were Hamas officers. And in such a case, you have to decide what to do, because the other alternative is to let them in. And then they can, kill the settlers in the other side or army soldiers. So that is the dilemma that we had. By the way, that case you have asked, it was filed, the petitions were filed to the court. We heard it within 3 days, and we issued a full judgment with 50. I didn't sleep at all, though. But we issued the judgment within another week, and now it's been cited all over the world. And I can tell you that the many U.S. jurists in the universities support our judgment. There is, of course, there is also criticism. I wouldn't deny the fact that there is also criticism, but and then we said that in the other 20% of the cases that we don't know whether the people, it's ex post facto, we don't know whether they were military activists of the Hamas. Still, if there was a mistake, or sometimes you miss the target. It also happens. All those cases that should be checked by the army in order to improve the checks and balances next time, and to draw lessons from what happened there. And really later on, first of all, for a while it stopped. Unfortunately, in the last week it started again, so in heavy numbers. But that is the situation, and it's true that in such a case we have to fix as much as we can the facts as well. And again, you have to understand that in those cases it's something that never ever exists in any other court in the world. That during the time of so-called quasi-war, the Supreme Court is hearing the case, and you don't have it in any other court. From many other doctrines like unjusticiability, or because some of the organization. One petitioner was the civil rights organization of the Gaza people. And I didn't ask them in this case, but in a prior case, I asked them, in Gaza, you have a court to, you are an organization for civil rights. What are you doing in Gaza as far as civil rights are concerned? What are you doing with our, the dead bodies of our soldiers whom you keep and you even do not disclose whether they are in your hands or not? Are you active there as much as you are active in our jurisdiction, being an organization for civil rights who is organized in Gaza and just make petitions in Israel and not in Gaza? But I'm just leaving it like that.
Yes, sir. Let this be the last one right here. Go ahead.
Thank you. I'm Jack Wiener, and I'm an attorney, but I
And
also...
a professor of law.
Yeah,
Okay.
thanks. And one thing I teach is the law of war. I wonder if you could speak to the following interesting mismatch. There's a mismatch at times between how the Israeli Supreme Court might view an issue and how either the international legal community or a specific country's judicial system might view it. So how does this come up? An example would be Spain decides, oh, we think that Israel's engaged in war crimes. In our view, we believe we have jurisdiction, so if Bibi Netanyahu happens through the airport, we'll grab him and we'll try him for war crimes. How do you see this moving forward? The ability of countries to say, I think another country that I'm not involved with has committed a war crime, but we're not going to defer to their Supreme Court on the issue, we'll just take it into our hands. What do you see the way going forward?
Okay. First of all, we do our best to decide a case according to the Israeli law and according to the humanitarian international law as we understand it. Of course, there may be any disputes, but as you are an international law professor, you understand that for the time being, there is no one jurisdiction that decides on those issues. And there is no such a form. There is a criminal court that in some cases can hear such cases, but again, there should be a consensus, and we are not yet there whereby there is one form that is considered the ultimate form to decide. So we do our best, and unfortunately, we have more experience than most of the courts in the world in terrorism matters and in cases like that. As I told you, in the case that you mentioned, we were the first one in the world to tackle such a problem, and unofficially I can tell you that many courts in the world, Supreme Courts, whenever they tackle new problems, they organize a seminar, so it's called, with us, to hear how we deal with a problem. It's an unofficial seminar. How we deal with matters that didn't come before them before, but they have to deal with them, usually in Europe. I don't want to go any further, but I'm telling you that many courts as such, or justices personally, are interested in our experience and in our judgment. Here, when I see the General Council of Israel, we ask many times that the Ministry of Foreign Affairs will translate all our judgments in those matters into English, because, again, my suggestion was that we'll do it immediately after we issue such a judgment. So they said, okay, but it takes about a year or two till it happens, and it's unbelievable that we need the help of several universities in the United States in order to have those judgments translated. And whenever there is such a request for a different court, then we get a special budget for translating the cases. So that is the truth and that is the fact.
Thank you.
I would like, first of all, if you allow me,
Absolutely.
Justice Melcer, also to thank the hostess and to say that I was looking at the beautiful view from your window, and I had two options, whether to look right and get angry at the United Nations, or to look to the left and be proud of the Technion, Israeli Technion campus here in Roosevelt Island, which is really one of the sources of pride that we have here in New York as Israelis. So I opted for the left. It's not usual. It's not my usual choice.
Or to look in this building and to look at Trump.
But I would like to say that I have some observations about what Justice Melcer said, but I don't think this is not
that shows us that we are independent.
Exactly.
Yeah.
Not the forum to, but I will say that, as Justice Melcer said, you know, that Israeli Supreme Court justices and justices at all, they don't have public hearings in the Knesset, in our parliament. But I can assure you that if we had, even though I don't know what Justice Melcer did as a high school student, he would be approved unanimously, and you know that there are justices of the Supreme Court whose 70th birthday are celebrated by all the population of Israel. Justice Melcer's 70th birthday will be celebrated only by Margalit.
Thank you.
Thank you very much for coming. Thank you. Enjoyed it.